The topics that we cover in this particular series are the ones which are appearing in daily newspapers, how they can be beneficial for you to increase your knowledge, plus understand the topic and use these in any answer or any discussions or any other interview. With today's topics include the the conflict that is going on regarding and the talk and the debate that is going on regarding the redistribution of wealth. So there is a news article that has appeared in the Hindu today. So courtesy The Hindu, whatever has been written by the author, actually we will be debating and discussing it. So what is the redistribution of wealth? How it is going to help society? How it is not going to help society? What are the effects on the policymakers? And what is the effect on economy overall? We will be going through it. Second comes COVID vaccine linked to blood clot GS3. You see, India, when it was fighting the COVID issue, that time also it administered Covishield, and that Covishield actually was manufactured in collaboration with Oxford University AstraZeneca, and the Indian manufacturer who was the primary actually supplier of this. So, in a new recent case in British judiciary, the AstraZeneca, a company, has actually said that this particular vaccine may cause, in the rarest of the rare situation, the blood clotting, etc. So we will deal with it, how it is going to, affect the Indian people, and what its effect will be. Then comes El-Nino and related heat waves. Those came in the eastern part and the southern part of the country in April, and the association with the El-Nino. So this will be covered in our geography section, that is GS1. So let us start with first one about the redistribution of wealth. When we talk about the redistribution, we should remember one thing, that the redistribution actually is one where the uh, money is being or wealth is being taken from the richer and is being given to the poorer. It is as simpler to understand as, after independence, India did try to redistribute land and property as well. The land actually was given to, first of all, it was pooled, and then after from that pooled, it was given to the people, so that the people have some sort of socialistic mode of production where state controls whatever the uh, resources are with the community, how they are going to be utilized. But when we talk about the capitalist mode of production, then these kind of systems actually are not uh, a valid things. In capitalist mode of production, what happens is those who have will be having to their, or because of their labor and other factor of production. Suppose a capitalist actually put money in a market or put a money in a particular adventure, then he takes a risk, and because of the risks and the capabilities that he has, he amasses wealth because of that only. So that is a capitalist mode of production. In the capitalist mode of production, you must also know that the state control is either minimal, or in even those circumstances where the rarest of the rarest things, like either the recession is coming or some sort of emergency situation is arising in particular geography. So in a capitalist mode of production, this is very, very least. But when you talk about the socialist mode of production, the control of the state is higher. So when the control of the state is higher, then we talk about the redistribution of wealth or redistribution of the resources. Redistribution of the resources are achieved, number one, to achieve parity among the people. It cannot be equality, but at least some sort of equity in on the basis, or even some sort of equality on the basis of outcome as well. So this is one of the thing actually, that the redistribution either of wealth or property is achieved. Number two, in a highly diverse society where the inequality among the society is increasing, the political class actually raises these kind of points to not only see votes, but also not only to fetch votes, but also actually to target the section of population that has remained to the bottom section of the society. So the societies which are highly unequal, the chances like that actually will arise. In a highly diverse society and the highly unequal society, where the inequality or the gap between the richer and the poor is increasing, the problem of the civil strife actually can also come to the fore. Civil strife in the sense that those who feel that their resources are being cheated upon, are being taken upon by the richer people, they may start the social strifes. They can rage in the revolt, they can do the civil war, etc., and it can be also dangerous for the overall situation and internal security of the country. But is the redistribution of wealth a good idea? That has its own ethical concerns as well. The ethical concern is number one, that people who have their own abilities, they will not be able to work to their advantage because it is the state whose role will be increasing. Number two, what will be the cutoffs? Means, when and how we will be determining that this is the wealth, criteria, and those who are below it, we will be distributing it, and those who are above it, those are above it, actually, we will be distributing after taking away that wealth, and those who are below will be, given that particular wealth. It also creates a problem of work as well. So the ethical concerns about work also can get affected because those people who do not work or do not possess the uh, amount of thinking levels or aptitude or attitude levels, they may not even work because the state is then duty bound to give you the entitled benefits. So why would they work? So the overall situation or the overall economic resources in the country may flow down. So when you try to talk about redistribution, it has its own ethical concerns. Only ethical advantage actually that is seeming with the redistribution of wealth is achieving a society that is equal, where the justice is available to everyone in the form of highly equal or some sort of health backing or education or livelihood backing is provided by the state. But other ethical concerns are in the form of that people may not want to work at all. What will be the cutoff date? Where we will be deciding that okay, this is the criteria under which actually people wealth will be with them only, and above which actually the state will take it and then after will give it. And third, what about the decision actually that okay, who will be doing it? Whether there will be leakages in the system or are there any property related things or these things. So now we talk about the redistribution of wealth. Redistribution of wealth has been a primary concern. Redistribution of wealth actually has been in Indian talking sense also. So when we talk about couple of articles are also in the sense that article when we talk about inadequate resources with the government and to provide greater flexibility in acquiring land for public welfare, various amendments were carried out that curtailed the right to property. Notable among them were exceptions under Article 31A, 31B, and 31C. So when we talk about Article 31A, it was done through First Amendment 1951, and it provided that laws made for the acquisition of estates, etc., shall not be void on the ground that it violated fundamental rights, including right to property. So Article 31, Article 31A that was brought by First Amendment of 1951 provided for the acquisition of estates. Article 31B that was also provided by the First Amendment 1951 itself made laws placed under the ninth schedule immune from the judicial review. As you know, ninth schedule of the Constitution was brought in to make sure that all the changes that Parliament does are not for the judicial scrutiny. So they are out of the judicial scrutiny. So in 31B, Article 31B, First Amendment that 1951, it did make laws placed under ninth schedule immune from judicial review on the grounds of violating any fundamental rights. When we talk about a particular case called Kohilu case of 2007, the Supreme Court held that laws placed in ninth schedule after April 1973 would be subject to judicial review also. When we talk about Article 31C, 25th Amendment 1971 that was brought in by 25th Amendment 1971, it provided primacy to the DPSPs under Article 39B and 39C. So laws that were made to fulfill these principles shall not be void on the ground that it violated fundamental rights, including right to property. Even fundamental rights under Article 14 was also given a pass over if that was having to do with Article 39B and 39C of the DPSP. So such was the Article 31A, B, and C ground. So when we talk about the debate surrounding the redistribution of wealth, where does it fit in the constitutional framework, and how is the judiciary ruled on the topic from the start? We also know that the preamble of the Constitution aims to secure to the citizens in economic, social justice, liberty, and equality. Part 3rd of the Constitution lists down the fundamental rights that guarantee liberty and equality, while Part 4 of the Constitution contains the directive principles of state policy. Directive principles of state policy talk about ownership and control of the material resources, and these are the principles that the center and the state governments should follow to achieve social and economic justice in our country. The Supreme Court in various cases has interpreted the relationship between fundamental rights and DPSPs. When we talk about there has been a conflict between fundamental rights, say, to property and directive principles of a state policy to say Article 39B and 39C. Even actually Article 31A, etc., has been also in the picture. So there has been a constant debate about the relationship between fundamental rights and DPSPs. In the year 1978, Supreme Court, in order to avoid excessive litigation directly in the Supreme Court by the properties class, the 44th Amendment Act was omitted. 44th Amendment Act was brought in, and it omitted the right to property as a fundamental right, and it made a constitutional right under Article 300A. So when you talk about the fundamental right, it was removed. Right to property was removed from the fundamental right doctrine, and it was put as a constitutional right under Article 300A. It does mean that the right to property was made a less secure a right. When you have a fundamental right, it means it is governed by the fundamental laws of your country. Number two, it is very difficult to change, or bring changes into the fundamental rights. In a simple constitutional right, it is very, very easy to change them. So when you were having a right to property as a fundamental right, it does mean that you can directly approach the Supreme Court if the violation of the fundamental right to property happened. But in this particular case, it was not available because it's a constitutional right, so you cannot reach to the judiciary under violation of Article 32. So that was also one of the reasons that it was brought in as a constitutional right. So the right to property was brought in to only make it less secure. The Supreme Court has now constituted a 9-judge bench to interpret the directive principles of state policy. So this is the current situation, and on a daily basis, the arguments and counter arguments are going on in the Supreme Court about this particular issue. So the Constitution, when you talk about it, the preamble of the Constitution aims to secure to the citizens all social and economic justice, liberty, and equality. When you talk about the principles that the center and the state government should follow to achieve social and economic justice in the country, unlike the fundamental rights in Part 3rd, the DPSPs are not enforceable in the courts, but they are nevertheless fundamental in the governance of the country. Because DPSPs ensure that what will be the mode of the governance in the country. DPSPs also make sure that when the resources are with the government, or as the capability of the governments increase to spend resources, what the government should do. So DPSPs are kind of positive rights that show the path to the governments. Article 39B and 39C in Part 4 contain principles that are aimed at securing economic justice. They provide that the ownership and control of material resources of the society should be distributed to serve the common good, and that the operation of the economic system does not result in the concentration of wealth to the common detriment. So the words are concentration of wealth and common detriment. So Article 39B and 39C actually has been given this kind of language. Again, I would like to talk that Article 39B and 39C in Part 4 contain principles that are aimed at securing economic justice. They seek to provide the ownership and control of material resources of the society should be to distribute, or the material resources of the society should be distributed to serve the common good, and that the operation of the economic system does not result in the concentration of wealth. As I talked to you that in a, when we talk about Article 31B and 31C, in 31C, the 25th Amendment Act 1971 provided primacy to the DPSP under Article 39B and 39C, and it was said that laws made to fulfill these principles shall not be void on the ground that it violated fundamental right to property, including the constitutional rights to property and fundamental rights under Article 14. Then we talk about what is the historical context. So the Constitution originally guaranteed right to property as a fundamental right under Article 19(1)(f). It provided under Article 31 that a state shall pay compensation in case of acquisition of private property. So because it was a it was a fundamental right. So any kind of detrimental to that fundamental right under Article 31, the state was duty bound to pay compensation in case of acquisition of that private property. And it is pertinent to note at the time of independence that the main property rights related to agriculture and other land. The government had to acquire the rights in such estates for carrying out land reforms and construction of the public assets. As I told you, when we got independence, the government actually first did try to do the land reforms. The lands actually were taken away from the zamindars and was given away to the actual tillers. And to do that, it was a very tedious task because we were having right to property under Article 19(1)(f), and as the government started doing it, the zamindars and the landlords actually started approaching the Supreme Court as that the violation of our fundamental right is going on. So the government had to acquire the rights in such estates by for carrying out land reforms and construction of the public assets. Considering the inadequate resources with the government, and in order to provide greater flexibility in acquiring land for public welfare, various amendments were carried out, and those curtailed the right to property. Notable among them were under Article 31A, B, and C that are briefly explained earlier. So the Supreme Court in various cases has interpreted the relationship between fundamental rights and DPSP. So few of the cases are notable. Most of these cases were against constitutional amendments made by the government that curtailed the right to property that was then a fundamental right. When you talk about the Golaknath case, the Supreme Court held that fundamental rights cannot be abridged or diluted to implement DPSP. So in the Golaknath case, it was said that DPSPs cannot be given primacy, and DPSPs actually fundamental rights cannot be abridged or diluted to implement the DPSPs. In the Keshavananda Bharati case, a 13-judge bench order of the Supreme Court upheld the validity of Article 31C but made it to the subject of judicial review. Because in Article 31C, when it was brought in by the 25th Amendment Act, it was said that even the judiciary cannot judicially review it. So the Supreme Court said that judicial review is the basic structure of the Constitution, and any law that is made by the Parliament or the state governments cannot be out of judicial scrutiny. So they said that it is subject to the judicial review. When you talk about the Minerva Mills case, the Supreme Court actually ruled that Constitution exists as a harmonious balance between DPSPs and fundamental rights. So the debate when you talk about the DPSPs and the fundamental rights, it has been, you can mention all these cases like Golaknath case, you can mention Keshavananda Bharati case and the Minerva Mills case. Last one actually where the Supreme Court ruled that the Constitution exists as a harmonious balancing between fundamental rights and directive principles of state policy. In 1978, in order to avoid excessive litigation directly in the Supreme Court by the propertied class, The 44th Amendment Act was brought in. 44th Amendment Act omitted right to property, as I told you, and made it as a constitutional right under Article 300A. Right to property continues to be an important constitutional come legal right, but the guarantees that has been given as a fundamental right has been taken away. So what is the current debate? So as of now, right to property is under Article 300A. So any law to acquire private property by the state should only be for a public purpose and provide for adequate compensation. So the current government, Indian government in the first 4 decades after independence followed a socialistic model of economy. There were many laws made by the center and states to acquire land from zamindars and big landlords for public purpose. The economic policies resulted in the nationalization of banks and insurance, extremely high rates of direct taxes, estate duty on inheritance, tax on wealth, etc. There were also regulations that placed restrictions on the growth of private enterprises like the monopolies and Restrictive Trade Practices (MRTP) Act of 1969. So the rationale behind these measures during those times was to reduce inequality and redistribute wealth among the poorer sections who constituted majority of the population. However, as I told you, these kind of measures stifles entrepreneurship, growth, and also resulted in the concealment of income and wealth, and even to those hands which were not able to properly utilize that particular wealth because those people might not be having the skill sets required to use those resources to their fulfillment. Taxes like estate duty and wealth tax generated revenue that was much less than the cost incurred in administering them. In the 1990s, the country moved away from the closed system of the economy towards liberalization, globalization, and privatization. It means LPG reforms. A new industrial policy was brought in July 1991 with the objective of empowering market forces, improving efficiency, and rectifying deficiencies in the country's industrial structure. The MRTP Act, which actually was brought in 1969, Monopolies and Restrictive Trade Practices Act, was repealed and replaced with the Competition Act of 2002, and income tax rates were reduced considerably. Estate duty was also abolished in 1985 and wealth tax in 2016. The market-driven economy has resulted in the additional resources for the government that has helped in bringing people out of abject poverty. This economic system has also resulted in growing inequality. So when you talk about it, that what is the basis of talk about redistribution of wealth, you can say that although we have brought in market-driven economy and it has caused growth to the Indian economy, but it has also caused, uh, inequalities that are causing actually problem on the system itself. The economic system has resulted in growing inequality. So a report by the World Inequality Lab states that top 10% of the country's population have a share of 65 to 57% of the wealth and income respectively. The bottom 50% of our population, on the other hand, has a meager 6.5 and 15% of wealth and income. That's why these kind of things actually has been brought in again. So the talk about redistribution of wealth is being brought in to just make sure that the voters, those who are at the bottom of the strata of the society, goes behind these kind of things. So there are arguments and counter arguments, while the Supreme Court meanwhile has constituted a nine-judge bench to interpret whether material resources under Article 39B included private property as well. So what can be the way forward? So when you talk about the author says that it is not just in India, but growing inequality is a worldwide problem of a liberalized open market economic system. However, it is the responsibility of the government to protect the interests of the poorer classes who are most dependent on the state machinery for their livelihood. At the same time, past policies of extremely high tax rates, estate duty, wealth tax, etc., did not achieve their desired goals. Instead, they only led to the concealment of income and wealth. Innovation and growth should not be curtailed, but the benefit of growth should reach to the all section of society, especially the marginalized. The policies may vary and need to be framed after adequate debate in line with the current economic models. Underlying principle to be achieved nevertheless remains the same, and that is economic justice for all, as has been enshrined in our constitution. So this should be the stated goal, but entrepreneurship and the innovation and growth in the country cannot be taken for a ride. Then we come to the second topic, and that is COVID vaccine linked to the blood clots. The lawsuit in the UK on COVID vaccine. When we talk about what is the matter, so the matter is like this, that pharmaceutical giant AstraZeneca has said that its vaccine AZ-1222 vaccine, which was made under license in India as a Covishield. So the Covishield actually was made under license by AstraZeneca in collaboration with the Serum Institute and Oxford University. So the vaccine was AZ-1222. And AstraZeneca in the court actually says that it can cause low platelet counts and cause the formation of blood clots in very rare cases. So very rare cases, one of the keyword is this, and second is it can cause low platelet count and cause the formation of the blood clots. These characteristics are linked to the thrombosis with thrombocytopenia syndrome. Thrombosis with thrombocytopenia syndrome. So for the first time, AstraZeneca has accepted it. Based on this formula, the Serum Institute of India manufactured Covishield, which has been administered to close to 175 crore Indians. AstraZeneca spoke about thrombosis with thrombocytopenia syndrome in court documents following a suit that was filed against it in the United Kingdom. The company is being sued over health claims related to the vaccine, which was developed along with the United University of Oxford in 2020. So the UK's Telegraph reported that with more than 51 cases being filed, damages worth around $100 million are being sought. In court documents, AstraZeneca denied that thrombosis with thrombocytopenia syndrome is caused by the vaccine at a generic level. However, it admitted that it can happen to the very rare of the cases. TTS, that is thrombosis with thrombocytopenia syndrome, is linked to a range of symptoms including breathlessness, pain in the chest or limbs, pin-sized red spots, and bruising of the skin in an area that is beyond the injection site, headaches, etc. Thrombosis can also block blood flow in both veins and arteries. Complications actually depend on where the thrombosis is located. The most serious problems include stroke, heart attack, and serious breathing problems also. So these are the effect where the TTS, thrombosis with thrombocytopenia syndrome, can cause. Early reports have said that before the vaccine rollout in 2021, the Indian government has said in a fact sheet that Covishield should be given with a caution to people having low platelet counts. In March 2021, many European countries temporarily paused the use of AstraZeneca's vaccine after a few cases of blood clotting actually were coming to the fore. The World Health Organization also acknowledged the cases and said that, based on the latest available data, the risk of TTS means thrombosis with thrombocytopenia syndrome with Covishield vaccines appears to be very low. Data from the UK suggests the risk is approximately 4 cases per million adults, means 4 cases per 10 lakh adults, while the rate is estimated to be approximately 1 per 1 lakh in European Union. So they said that in Indians it is rather on a more secure platform as compared to the Europeans, because the risk in European is 1 per 1 lakh, while the risk with Indians is 4 per 10 lakh. At that time, the World Health Organization in its report said the Indian government in May 2021 also said that based on the total doses administered, the incidence of TTS-like events was 0.61 per million doses. So Indian government actually, gave the statistics and said that it is only 0.61 per 10 lakh. It does mean that 6 per 1 crore. The Ministry of Health had termed this as minuscule and said that Covishield continues to have a definite positive benefit risk profile. It does mean that those who have got administered those who have been administered the COVID vaccine are actually in a much better health because they have been secured from the COVID that time. And the rarest of the rare cases are only 0.61 per 10 lakh people. More recently, the government's Committee on Adverse Events following immunization said that at least 36 TTS cases means thrombosis with thrombocytopenia syndrome cases have been confirmed due to Covishield. In the report that was made public in June 2023, around 18 deaths were reported. So out of all those 175 crore doses actually that was administered, the Indian government's latest data talks about 18 deaths that has been caused with TTS. For Covaxin, no potential thrombotic events have been reported. AstraZeneca, even the Indian experts also said that AstraZeneca admits rare side effect vaccine, but benefits outweighs the risk. They said that the risk is only 0.61 per 10 lakh, and as per World Health Organization, this is close to 4 per 10 lakh, and in the UK, it is close to 1 per 1 lakh. So when the COVID was raising its head, and people were going away here and there for oxygen searching, etc., and the people were dying like anything, economies were suppressed. It is important for the global people actually, to bring or global science to do its research faster and in a manner that can secure the lives of the people. So the benefits that had been received by this is much, much larger than the cost that has been attached. But it's also a lesson for the country's regulators that if any kind of, symptoms to show these kind of things should be then minimized to the lowest level possible. Although for the regulators, it's a dilemma because number one, on the one hand, they have to save lives. They have to also make sure that the society does receive the benefit of it. But on the other hand, they also have to ensure that the potential health problems in the future or in the nearest term actually does not arise. So for the regulator, this is a particular dilemma. But as the cost actually over outweighs the benefit, sorry, as the benefit outweighs the cost, it is important for the regulators to also see at this particular phenomena. As of now, in India, no such lawsuits has been filed. Can Indians go and join in the UK? Indian jurisdiction do not allow it because any kind of lawsuits has to be filed in India itself. If any kind of damages are to be asked, then it has to be fought in the Indian jurisdiction only. So it is the fight that it is why it is the fight that is being fought in the UK courts. But Indians, those who have been affected, like 18 cases out of 175 crore doses that has been administered, if there are some concerns, then they can be met in the Indian judiciary only. Then comes El-Nino, anticyclonic systems. Why large parts of India experienced heat waves in April? When you talk about it, this is a particular phenomena where, according to the Indian Meteorological Department, the heat waves has been felt in the eastern and southern parts of our country. So this is the news bulletin. So when you talk about it, why it has happened, then we should also understand that El Nino. So for 26 days this April, either a small pocket or a considerably large geographical area in India experienced heat wave conditions. While the southern peninsula and the southeastern coastal areas have been the worst affected, the northern plains are yet to experience heat wave conditions this season. When you talk about it, part of the Gangetic West Bengal, Jharkhand and Odisha witnessed severe heat waves and high temperatures. For instance, temperatures touched 47.2 degrees Celsius, that is 10.4 degrees Celsius more than the normal temperature in Kalaikunda of West Bengal, Paschim Midnapur district. Heat wave conditions are generally experienced over north, northwest, Central and East India, and Northeast Peninsula, together called the core heat wave zone during the summer season of the months. Rajasthan, Punjab, Haryana, Chandigarh, Delhi. These are the and Odisha, Vidarbha, Maharashtra, parts of Gangetic West Bengal are the most heat wave prone zones or states. IMD declares a heat wave. IMD means Indian Meteorological Department declares a heat wave when maximum temperatures at a station in the plains reach 40 degrees Celsius or more, 37 degrees Celsius or more in the coast, and 30 degrees Celsius or more in the hills. The severity of a heat wave is determined by its departure from the normal temperature. Normal heat wave is declared if the departure is 4.5 to 6.4 degrees centigrade. A severe heat wave is when the departure is more than 6.4 degrees Celsius. So a heat wave could also be declared based on the actual maximum temperatures. If it is more than 45 degrees centigrade, if it is more than 47 degrees centigrade, those two conditions will be known as. So if it is greater than 45 degrees centigrade, it will be heat wave will be declared, and if it is greater than 47 degrees centigrade, then severe heat wave will be declared. So large parts of India have witnessed heat waves and high temperatures for two reasons. Number one, 2024 is a year that began in an El-Nino state. As you know, the El-Nino weather pattern refers to an abnormal warming of the surface waters in the equatorial Pacific Ocean, and it leads to extreme heat in many parts of the world and the oceans. It developed in June 2023, and generally the years that follow an El-Nino event experience extreme temperatures, harsh, multiple, and extended heat wave spells, and lack of pre-monsoon rainfall. Persistent presence of the anticyclonic systems over the southern peninsula region and southeastern coastal areas is also partly responsible for a very warm April. These high-pressure systems, which exist at an altitude of about 3 km in the lower atmosphere and extend between 1,000 to 2,000 km in size, push the air underneath them towards the Earth, in the process called the air subsidence. And because of the air subsidence, the forcefully sunk air generates more heat on the surface closer to the Earth. So the presence of anticyclonic airflow also favors wind flow from the land towards the sea and prevent the incoming cooler sea breeze, which is otherwise responsible for cooling the air. So the air that is coming from sea towards the land actually, because of the anticyclonic airflow, can get reversed and it can be from the land to the sea. So that also causes a problem. So these are the situations why the heat waves have occurred. So we stop here. Thank you for listening to our lecture. If you feel that we were able to deliver some good quality content, you can share it and you can like. Thank you. For more such videos, you can like the button and subscribe the channel. Thank you.